Thank you very much. So this is one of the cases, one of the few cases where a Swiss court was dealing with a kind of transportation or maritime matters. That is not very often in Switzerland. This is a judgment from 2015, not a very new one, but I think it is very significant, and you will see why. Do I go with page down or?
You can use both. You can use page down, or
You
you may
can use mouse
use,
or presenter.
or even this one.
No, I would prefer, here it does. Okay.
Yeah.
Yeah. So I will briefly explain who is who and what happened in this case. What are the surveyor's reports and the surveyor's conclusions, and then the legal action before the Commercial Court of Zurich, and that is supposed to be the best commercial court in Switzerland. The judgment was brought to the Swiss Federal Supreme Court, and luckily there are also some German court cases in this field. So what happened? There is a company R in Switzerland that manufactures machines for the production of hygienic products. This is what this machine looks like. It has a lower part, more or less closed, divided by a kind of panel, and then an upper part. This is a kind of usual product of this company R. When a product is finished, then R gives an order to the company E to pack the machine in order to be transported wherever it is needed. So that was so also in this case. What was contractually agreed to supply packaging, including corrosion protection. And in the year 2009, the R got a new order, a big order from a new client from Australia to send 5 tailor-made machines, not just the ordinary machines, but tailor-made machines for this new customer. So the machines were finished, brought to the company E to be packed, and they were sent to Australia. As usual in Switzerland, everybody has an insurer. So the company R had its usual marine insurer, but this shipment was so big, so important, larger than any previous one, and they wanted really to be sure that they are well protected and that nothing will happen. So they took out an additional marine policy just for this shipment, and that was with the company where I was working, and that is how I got involved into this case. The packing company, they had their usual business liability insurance. So what happened when the machines arrived to...
Okay, this is force majeure.
That is not good.
No, I don't think they, because it was lights and everything.
Here it works.
If they have some generator, that will be okay.
Luckily, his brother is studying electrical engineering, so he picked up some.
There's also a cabinet there, like similar to that.
Right, he must have like.
Ima,
Sorry for that. Oh, it's coming back.
Okay. Change to that, okay. Excellent.
Thank you.
Bravo,
Ne, onda će opet,
Čega? Dođite dobro. Budi tako dobra pa ovdje odmah sa gospodinom Tomislavom u tajniku ovoga riječi. Sve na stipendiju.
okay. So the machines were packed, insured, and brought to Australia. And there the buyer discovered a serious corrosion damage and, of course, informed the plaintiff immediately. And that is the company R. They informed us, and everybody was in shock that such a damage could happen, because really all the precautionary measures have been taken. And then a meeting was there was a meeting of all the companies and their insurers, and so we were explained how the machines had to be protected against corrosion. It was explained how this is another manufacturer C of those volatile corrosion inhibitor and vapor phase corrosion inhibitor, and so on and so on. So it was explained to us that are not so technically involved in those things, how this normally functions and how that protects the seal surfaces of the machines and so on. And during this, I cannot say negotiations, but during that meeting, I remember very well the employee of the packing company, just the guy who was packing these machines in questions. He said, well, yeah, probably more of those vapor phase corrosion inhibitors, these are dispensers, probably more of those should have been used. To me and to others, of course, we haven't overheard that. That was a kind of saying, okay, I made a mistake. I should have used more. There were several experts who saw the damage, and we sent one of our best experts from Switzerland to fly to Australia to be there and to see the damage. And they were two professional, normal, local experts, and these photos are taken from their survey reports. So the containers were open. There were no outer damage on the container. In each container, there was a wooden crate or box, or no outer damage on that neither. No signs of any external intervention, no ingress of water from outside. So from outside, everything was fine. And only when the layers of this film or foil were unpacked, then the damage was visible. And on this photo, you can see these are the edges of the foil. So the foil, one sheet of it was not big enough to pack the whole big machine. So the parts, the edges of it had to be put together with these adhesive stripes where the name of the packing company is visible. So that's how they packed the machine into the foil. This is again a photo of this foil, but what the surveyors find, this sealing was not always watertight, not always tight. So there were gaps in the foil. One of those was 40 centimeters, so that the excess, the moisture from outside could ingress to the foil, to the machine, and even there were droplets of condensation, so droplets of water already sown under the foil in the room where the machine was. This is one of those dispensers that the guy said more of those should have been used. And each main machine had also a control cabinet, and they were packed separately, and they were smaller. So one sheet of that foil was big enough to pack this control cabinet, and out of 5 control cabinets, only 2 had minimal signs of corrosion, minimal, and 3 were okay. These are other examples of rust. You see it here. And you see it here very well. Not only rust on the surface, but also pitting corrosion. That's what the experts find out. So their findings or their conclusions in the text, this upper part, top part of the machine may have justified the use of more than just 2 foam dispensers. There were no drain slots at the bottom sheet of the package. And as you saw, those foils, they were not properly sealed. So the conclusion is that the machines had not been packed in accordance with the guidelines of the manufacturer of these anti-corrosion devices. As I said, there was no external damage to the crates, no cracks on the foils, but not the foils were well sealed because this wrapping, these foils did not have sufficient length. And there were no desiccant units found everywhere. So they were not put together. And when you buy a suitcase or whatever, you find a desiccant unit, although maybe it is not made of metal that can corrode. And here, no desiccant units were used. So to go on, the main internal components showed surface rust and pitting corrosion on the unprotected internal steel parts. And they were where there was no powder coating and no spray of that anti-corrosion film and so on. And the surveyor said it is possible that the use of more foam dispensers may have been insufficient. So this is a very, very soft formulation. It is possible that it may have been insufficient. He didn't say they were 2, they were supposed to be 4 or 6, but rather sometimes as if he were insecure in this finding by himself. But he said it is possible that they may have been insufficient. On the other side, there was no corrosion on other external panels, which were painted or powder coated. And he said this type of corrosion is typical for cargo sweat or condensation of atmospheric moisture that was observed there. Then, as you saw, there were gaps in the foil, in the sticking of the foil that allowed the entry of the moisture because they were not sealed or welded together. There were no drain holes, and there was no evidence of seawater ingress. That is also very important. And not all the recommendations of the producer of these anti-corrosion measures have been adhered to. So it is highly likely that compliance with all protective measures may have assisted in preventing, if not totally avoiding, the condensation corrosion that developed when the containers were moved from Europe in late November to Australia in midsummer. So that is the change of temperature. And so if they had complied with all protection measures, then it is very probable that the damage would not have occurred. The question was what to do now. The R was compelled to return the machines to Switzerland, to redo them. As I said, these were tailor-made machines for the new customer. So it could not just take another machine for another client and send it quickly to Australia. That didn't work. So it was a complete mess. Poor guys, they were really in a chaos. They had to overhaul quickly those machines, to adjust quickly another machine and send it as quickly as possible. Other clients were unhappy because he had to wait for the machines that they ordered. A total chaos. So the R reported the damage. As I said, it had 2 insurers for these machines, but we really tried to help those guys because they were really a good and reliable company, serious workers. And we appointed experts. We assisted in the negotiations with the packer and so on. But the transport insurance policy expressly excludes damage by humidity, temperature influences, and so on, or unsuitable or inadequate packaging. And this was clearly identified as the cause of damage. So we do our best, but we cannot pay the claim. And the business liability insurer of the packaging company, they said, we cannot pay because our insured is not liable for the damage. That is our standpoint. That was their official standpoint. But what the guy at the meeting said, we don't insure bad work. That means, in a way, he was sure this was a bad work, although even the packing company was a reliable company. But they made a mistake. Once they delivered a bad work, and the liability insurer said, no, sorry, we are not going to pay. And this is where I was working for decades in several insurance companies in Switzerland. And it is not so only in Switzerland. But when I saw this, so many premium amounts have been paid on both sides. The insurers have taken the money. Now a big exceptional case has happened and nobody pays. Okay, I was not very happy with that. And now when I think of that, I try not to get emotional with the situation again. So our client had no choice but to take a legal action, as I said before, the commercial court in Zurich, for more than 6 million Swiss francs, and that is about 6,600,000 euros. And there was all those surveyors' reports that I mentioned. Everything was submitted to the court, but Swiss courts treat expert findings as a mere party statements, irrespective of the good documentation, all kind of photos. It is just what the parties say, and the court is not bound by the surveyors' findings. So what the commercial court did, they appointed their own expert. Not anyone, just one guy from the Swiss EMPA, that is a prestigious company. So the guy was probably knew what he was doing. Unfortunately, I never got this report. And I don't know whether he flew to Australia or whether he inspected the machines back in Switzerland, whether he inspected them at all. But his conclusion was that the cause of damage was severe chloride contamination. I really cannot know. I don't know how could he come to such a conclusion. So the commercial court dismissed the claim because having this as a possible cause of damage, the plaintiff has not proven the causal link between the breach of contract for packaging and the damage that occurred. That was the position of the commercial court of Zurich. Of course, there was an appeal to the Federal Supreme Court, and the plaintiff maintained its position that the respondent in the contract between the two, that was a contract for packaging, but by doing that, the packer had guaranteed that the machines were free of corrosion, and that this part of the contract there was a breach. The court expert, contrary to our experts, he denied the causal link between the packaging and the corrosion damage, and he repeated he considered chloride contamination to be the cause of the damage. We were talking today about proxima, causa proxima, and so on. So the position of the court was that the packaging could not be regarded as the predominantly probable cause of the damage. There was a critique of the survey reports, of our reports, and maybe that was an omission of the lawyers on the part of the plaintiff. When the other expert said that was contamination by chloride, they had to say, okay, if it is so, maybe, but then the respondent is responsible for that as well. That is what they omitted to put in the appeal. So according to the findings of the contested judgment of the commercial court, the respondent undertook to produce seaworthy packaging, including corrosion protection. So the parties agreed with the lower court that the respondent has thus assumed the contractual obligation to produce the agreed packaging. But the lower court did not accept the view that the respondent had undertaken to deliver machines to Australia free of corrosion. So the packaging, including corrosion protection, didn't mean to be a guarantee for an arrival free of corrosion. Yeah, I don't know how to comment that. If they were not, if we were all if we took the position that the packing company took all the precautionary measures to inhibit the corrosion using this and that, if that were fine, then I may say, okay. But the experts established not all the precautionary measures have been taken out. So the corrosion protection that was part of the contract was not fulfilled as it should have been. So the lower court was unable to recognize that the respondent had offered a corrosion-free arrival or that the packaging would guarantee corrosion-free arrival. That is what I don't agree with. So, although they said, yeah, the machines should be able to be unpacked in Melbourne in the same condition as they were picked up, and that was not the case, and that was still not a guarantee. Okay, I just I just disagree with that. So the appellant maintains the view that the effective corrosion protection was guaranteed. And this type of contract is considered to be the contract for works and services, according to the Swiss Code of Obligations. And this type of contract guarantees the success of what has been done, not only to deliver the work, but only to deliver the success, the result of this work. So the contract, the court says the contract, the contents of the contract was just the packaging, and that was done. There were foils, crates, everything, but the guarantee for arrival free of corrosion was not a part of the contract of work and services in this case. The court didn't hear the argument that the packaging did not meet the requirements of packaging with anti-corrosion devices. The fact that the respondent disregarded the guidelines of the manufacturers of these devices, that was not an argument, and so on and so on. So the lower court interpreted the parties' contract that in the normal course of events, it could prevent the corrosion of machines that can occur without protecting during sea transport. So using all these measures was, in fact, would in normal course of events protect the machines from that corrosion. And they said the plaintiff did not prove the causal link between the breach of contract and the damage that occurred. And the standard proof is the preponderance of liability. So it wasn't necessary for him to prove 100%, but there is a preponderance that there is, it is most probable that that was the cause of that damage. But as the court's expert established another cause of the damage, the burden of proof was on the appellant, and so there were other causes that showed a higher or equally high probability that they caused the damage. So there were two experts and two opinions and two probable cause of damage. And having the two of them, the court said that the standard of proof of preponderance of liability has not been brought because there were also other possible cause of the damage. So the court correctly understood the standard of proof of preponderance of probability, because according to this standard, evidence is deemed to have been provided if there are such weighty reasons in favor of the correctness of the factual allegation from an objective point of view that other conceivable possibilities cannot reasonably be considered to a significant extent. And here there were other conceivable possibilities. That means that the plaintiff did not succeed with his proof. And this second possibility was this chloride contamination as also a possible cause of the damage. And the appeal was dismissed. So to repeat in short, what the position of the Federal Supreme Court was. The cause of the corrosion damage is not moisture ingress through improperly sealed foils or inadequate use of corrosion inhibitors, but severe chloride contamination, and that was according to the court expert. There was no causal link between the packaging and the corrosion damage. And the contract for works and services for seaworthy packaging, including corrosion protection, was for packaging of the machines in accordance with the specification for ensuring corrosion protection, but was not a guarantee that the machines would arrive free of corrosion. So that is the Swiss position in the final judgment. As I said, there are not very many Swiss court decisions in transportation matters. So Swiss judges and lawyers love to have a look to German court cases because there's much more materials there. And there are two German court decisions with practically the same facts, but with a totally opposite position of the court. They are both younger than the judgment from 2015 that I just explained, that I just presented. Maybe if these were known at that time already, maybe that would have influenced the Swiss court to think in another way, but that judgment is older than this one from 2019. So in this case, and that was a higher regional court in Hamburg, the plaintiff sought a declaratory judgment that the defendant is liable to pay damages due to faulty packaging of machine parts from Germany to Korea. So, and the main content of a contract for work and services was the packaging. But if a contract provides for a crate made of the placing of desiccants and so on, the result had to be preservation of the cargo and seaworthy packaging. So the contractor owes packaging that protects the good to the destination. And if the protective measures are not taken, then that is a prima facie evidence that the damage could have been avoided, and it was assumed that the corrosion damage was causally attributable to the breach of duty by the defendant. So there was no need for the court to take another expert, to have other exploring other possibilities and so on. If there is evidence that the protective measures have not been taken, that is a kind of preponderant cause of the damage, and it was said, yeah, it is causally attributable to the breach of contract by the defendant. This is a decision of the Regional Court of Essen, 2023. Again a machine, again a transport for Europe overseas, and again moisture damage was discovered. There was a contract for packaging of goods, and that means that is a contract for works and services. And the court said packaging is only seaworthy if it is so watertight that it protects from heavy rain, standing water, and condensation for a foreseeable period of time. And this sentence was taken over from the previous judgment. If the prescribed protective measures are not taken and danger materializes, prima facie evidence suggests that the damage would have been avoided if the relevant regulations had been observed. And in the event of water damage, this is the prima facie evidence that the damage would have been avoided if the goods had been packed in a seaworthy manner. So these two judgments with almost the same facts as the Swiss judgment showed a totally different position of German courts in comparison with the Swiss courts, and that was a kind of little relief for me. Thank you very much.